name is Chris MacLean, C-H-R-I-S-M-A-C, capital L-E-A-N.
And you're Sharon's attorney?
I'm Sharon's attorney.
Just talk to us about what happened in court today.
Well, we got through the arraignment process. Before we went into the court, we talked a little bit about some of the procedural things going on. From my point of view, the motion to disqualify the Attorney General's office, or at least the two prosecutors involved in the case, is my highest priority. I think it's been reported that they illegally obtained a whole bunch of psychological records and other documents relating to Sharon, and now we have to deal with the consequences of that.
But if they can't use that information, why is it so important for you to have them removed from the case?
Well, there are a number of ways you can use information like that. Just having knowledge about somebody's psychological profile, their strengths and weaknesses cognitively, assists in cross-examination or cross-examining an expert witness. So there are a number of reasons why privileged and confidential information is supposed to stay privileged and confidential. It's not supposed to be used for any purpose at all.
And does she, in fact, as far as you know, have an underlying mental health condition?
Well, we're exploring that. I can tell you that she has an underlying mental retardation, intellectual deficiency. So whether she has some other more complicated psychological issues, we're exploring that.
And she will have an evaluation ordered by the court?
There has been ordered by the court. It's been scheduled, I think, for April 20th at this point, but we're also doing some work with our own experts at this time.
What's your opinion of the way the state obtained the information about your client?
Well, they did it illegally on a number of levels, and there's going to be a hearing set up. I hope it's going to be on April 11th, so it could be as early as next week. I mean, you're not allowed to use a subpoena from the state of Maine out of the state of Maine, first of all. And you're not allowed to use a subpoena in a criminal case to get confidential and privileged records without getting a court order allowing it. And in this case, the AG's office, somewhat surprisingly and inexplicably, decided to skip those procedural safeguards and subpoena the records directly and have them emailed to them in one day, which is disturbing and not correct and a violation of due process.
Sharon's pretty far along in her pregnancy. How has that been affecting her time in custody at Two Bridges Regional Jail?
She seems to be doing pretty well. I was just noticing the lump in her tummy in the courtroom today. So she gets regular and appropriate medical care for that, and I think it's going really well.
Have you had the opportunity to meet with Julio's attorney at all? He said that we should stay tuned for some surprises that are coming up. Can you tell us anything about that?
Well, I would agree that there are always surprises in cases like this. Unlike Julio's new attorney, I have reviewed a lot of the underlying records and have gathered up really probably close to 2,000 pages of records at this point that we've been going through and reviewing. There are some surprises, but they're not. I think there is a good. I want to be careful about what I say, but what they tend to suggest is that what I've been saying all along is what's going to be borne out. So it's not really a surprise to me. The fact is that my client's been a victim of severe domestic violence in their relationship, and that's going to play through in a lot of ways as we move forward in this process.
The prosecutor file affidavits detailing their various involvements with those records they received from out of state. Have you had a chance to review that, and does that change your view at all on whether you're going to be trying to include the entire AG's office or just certain people?
Well, to answer the first part of your question, I did review what they submitted. You'll hear in court, if we do this next week, some of my concerns about what was submitted. I don't believe that the AG's office is compliant with the court's rule at this point. I'm not going to get into all the reasons for that right now, but it doesn't change my view at all. In fact, it only reinforces my view that the Attorney General's office should be disqualified from further involvement in the case.
Entirely?
Entirely. And at a minimum, these two prosecutors should be removed from any further involvement in the case.
The sense in which the entire AG's office, I know it's happened in the DA's office.
I've never heard of the Maine Attorney General's office being disqualified from further involvement, but I've also never in my 22 years seen a situation where this kind of violation of a defendant's rights has taken place in such egregious violation of the rules.
So you call this unprecedented misconduct?
I would call this a situation I've never seen before happen. It's surprising.
And if the judge does not remove those two attorneys, would that be kept there as grounds for future appeal should there be a conviction?
It certainly would. I mean, as we go forward through the process, what I'm trying to do is ensure due process for my client. We can't always ensure that we get a just result in the case, but we can always ensure that we have a just process as we go along. And part of my role as a criminal defense lawyer is to make sure that my client's rights are respected as we go forward, that the rules are followed and that the law applies to everyone. And when those laws are broken and the due process rights of the defendant are violated, that's something we always preserve for the record and take up on appeal. And when those rights involve a violation of the defendant's constitutional rights, is particularly important and often can result in the reversal of the conviction.
You hinted at another motion that you might discuss along with your motion to disqualify. Can you tell us anything about that?
Sure. I won't get into all the details, but I alluded to it a second ago in what I said. As part of my investigation in the case, I learned that the Attorney General's office routinely in criminal cases uses subpoenas beyond the jurisdiction of the state of Maine. And while I can't go and fix things for other criminal defendants and protect everyone's due process rights, I can seek an order prohibiting the AG's office or any other prosecutors from doing that to seek any other information against my client in this case. So I do anticipate filing a motion for protective order simply to require whoever is prosecuting my client to follow the law. Seems like a simple thing to me.
All right, thank you very much.
Yeah, thank you for your time.